Hello, everyone, and welcome to Civil Law. We are continuing our weekly recording session from Twitch because we didn't have any traffic over there. So we're going to start over and see what we got for anyone who is watching. So let's get started with this. For our story today, we have the United States Court of Appeals decision in Mozilla Corporation versus Federal Communications Corporation. Now let's try it again. For today's story, we have the United States Court of Appeals from the District of Columbia for the case of Mozilla versus the FCC. This is a case dealing with internet regulation and the ability of states to regulate the internet by net neutrality or otherwise when the FCC is no longer doing so. So as you may remember, the FCC had previously had a net neutrality regulation, but they withdrew that regulation and some states have tried to impose it on their own. The FCC has tried to stop this, and the Court of Appeals for the D.C. Circuit has ruled that the FCC cannot stop it because the authority that they had, they gave up to the states, and so the states can do it because they are not preempted. So we're going to read this decision and see what it has to say about preemption doctrine as it relates to the internet. So let's get started. In 2018, the Federal Communications Commission adopted an order classifying broadband internet access services as information services under Title I of the Communication Act of 1934, as amended by the Telecommunications Act of 1996. In doing so, the agency pursued a market-based light touch policy for governing the internet and departed from its 2015 order that had imposed utility-style regulation under Title II of the Act. Petitioners, an array of internet companies, nonprofits, state and local governments, and other entities, bring a host of challenges to the 2018 order. We find their objections unconvincing for the most part, though we vacate one portion of the 2018 order and remand for further proceedings on three discrete points. The 2018 order and today's litigation represent yet another iteration of a long-running debate regarding the regulation of the internet. We rehearsed much of this complex history in United States Telecom Association versus FCC, and we see no need to recapitulate here what was done so well and said so thoroughly there. In the interest of reader friendliness, though, we provide a brief review and certain highlights necessary to understand our opinion. As relevant here, the 1996 Telecommunications Act creates two potential classifications for broadband internet: telecommunication services under Title II of the Act and information services under Title I. These similar sounding terms carry considerable significance. Title II entails common carrier status and triggers an array of statutory restrictions and requirements. For example, Title II declares unlawful any change, charge, practice, classification, or regulations as unjust or unreasonable. By contrast, information services are exempted from common carrier status and hence Title II regulation. An analogous set of classifications applies to mobile broadband. A commercial mobile service is subject to commercial common carrier status, whereas a private mobile service is not. The Commission's authority under the Act includes classifying various services into the appropriate statutory categories. In the years since the Act's passage, the Commission has exercised its classification authority with some frequency. Initially in 1998, the Commission classified broadband over phone lines as a telecommunications service. Just 4 years later, though, the Commission determined that cable broadband was an information service, a choice the Supreme Court upheld in Brand X. The agency then applied a similar classification to wireline and wireless broadband. But the 2015 Commission took the view that broadband internet access is in fact a telecommunication service and the mobile broadband is a commercial mobile service. In USTA, this court upheld that classification as reflecting a reasonable interpretation of the statute under Chevron's second step. I share your feelings regarding Brand X, evil coleslaw. And Chevron, I'm sure, not my favorite cases. Once again, the Commission has switched its tactic. In 2017, the Commission issued a notice of proposed rulemaking seeking to revert to its pre-2015 position in re restoring internet freedom and released on the final order at that issue in the case in 2018. The 2018 order accomplishes a number of objectives. First and foremost, it classifies broadband internet as an information service and mobile broadband as a private mobile service. Second, relying on Section 257 of the Act, located in Title II, but written so as to apply to Titles 1 through 6, the Commission adopts transparency rules intended to ensure that consumers have adequate data about internet service providers' network practices. Third, the Commission undertakes a cost-benefit analysis, concluding that the benefits of the market-based light touch regime for internet governance outweigh those of the common carrier regulation under Title II, resting heavily on the combination of transparency requirements imposed by the Commission under Section 257 with enforcement of existing antitrust and consumer protection laws. The Commission likewise finds the burdens of Title II order conduct rules exceeds the benefits. We uphold the 2018 order with two exceptions. First, the court concludes the Commission has not shown the legal authority to issue its preemption directive, which would have barred states from imposing any rule or requirement the Commission repealed or decided to refrain from imposing in the order that or is more stringent than the order. The court accordingly vacates that portion of the order. Second, we remand the order to the agency on three discrete issues. The order failed to examine the implications of its decision for public safety. The order does not sufficiently explain what reclassification will mean for regulation of pole attachments, and the agency did not adequately address petitioners' concern about the effects of broadband reclassification on the Life and Land program. So, long story short, the Court of Appeals says that if states want to impose net neutrality, they can, because the federal government's FCC gave up its ability to regulate and it gave up its preemption authority. So although the FCC has said nationwide there is no net neutrality, individual states can say there's net neutrality, and several states have imposed net neutrality requirements. So that is a boon to those states. So let's go on to the issue of preemption. And I'm now going to skip a whole bunch of pages so we get to the preemption issue. These are 100 pages of issues that are not really what we care about for today's purposes. Skip, 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 skip. So much stuff that we don't care about. Skip, 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 skip. More skipping. Okay, there we go. Preemption. Next, we'll turn specifically to the portion of the court's decision that deals with the preemption issue. Preemption is the issue where the federal government owns the field of something. They take over the entire field. And so when the federal government preempts, it precludes any state from regulating in that field. There's a general power of states to regulate, but when the federal government dominates the field, they can prevent states from regulating. However, they have to do so very explicitly. They have to take over that power very explicitly. And this decision is saying that the FCC gave up its power to preempt by causing the regulation that they did. So they basically undid their own power by regulating the way they did. So we're going to read a little bit about the preemption doctrine. Finally, the FCC argues that we should leave the preemption directive undisturbed because the principles of conflict preemption would lead to the same result. Any intuitive appeal to this argument might have offered evaporated oral argument when the Commission confirmed what the preemptive directive's plain language bespeaks. It sweeps broader than ordinary conflict preemption. The necessary consequence of this position is that ordinary conflict preemption principles cannot salvage the preemption directive. Beyond that, the Commission's conflict preemption argument tries to force a square peg into a round hole. Conflict preemption applies to state law that under the circumstances of a particular case stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress, where that obstacle goes by the name of conflicting, contrary to, repugnance, difference, irreconcilability, inconsistency, violation, curtailment, interference, or the like. We have long recognized that whether a state regulation unavoidably conflicts with national interest is an issue incapable of resolution in the abstract, let alone in gross. Because a conflict preemption analysis involves a fact-intensive inquiry, it mandates deferential review until an actual preemption of specific state regulation occurs. Without the facts of any alleged conflict between us, we cannot begin to make a conflict preemption analysis in this case, let alone a categorical determination of any or all the forms of state regulation of intrastate broadband that would inevitably conflict with the 2018 order. Thank you, Naxari, for your donation. I watch all of your videos on demand and appreciate what you do. Thank you very much. I appreciate that you appreciate it. I appreciate that I'm helping things be understood, and I like to teach, and this is a good way for me to do it, right? So thank you for the $2 donation. It's very appreciated. The dissenting opinion, for its part, invents a brand new source of preemptive power that not even the commission claims. Always exciting. The power to preempt is said to derive from Chevron deference. Oh, Lord, have mercy. One of these days, I'm going to have to do a video just on Chevron deference and Brand X, because I have so many thoughts on Chevron and Brand X. So many thoughts. Oh, man. One of these days, I really hope the Supreme Court overrules it. It drives me crazy. Carrying on. And the deferential ambiguity that permits the commission to classify broadband under Title I. In the dissenting opinion's view, that interpretive ambiguity alone spawns a power to preempt all that might with an express statutory grant of authority. Wow. So for those of you who are not keeping track, they say that even though there's a statute, or in this case, not a statute, there is not a statute that says they can preempt. They say that Chevron deference gives them the authority to invent preemption from nowhere. From nowhere. Man. And you know what's really sad about that line of argument? It's actually not that ridiculous a line of argument. That's how far Chevron deference goes. Chevron and Brand X deference has gone to levels that are completely absurd. So as absurd as this line of argument may seem, even though there's no statute that says we can do it, we can just invent it. Chevron kind of says they might be right. That's how absurd Chevron is. Word of mercy. First, this asserted legal basis for preemption is not before us. The 2018 ordered two and only two sources of authority for the preemption directive: the impossibility exception and the federal policy of non-regulation for information services. It did not advance Chevron Step 2 as a source of preemption authority, so it cannot do so for the first time here. The Commission's brief here hewed to the 2018 order, advancing the two independent bases of authority plus ordinary principles of conflict preemption. Once again, the dissenting opinion's Chevron Step 2 theory is not there, so it is forfeited. You lost it, sir. Good day, sir. Of course, the Commission alluded to its Chevron Step 2 interpretation in explaining its policy reasons for design categorical preemption, but nowhere does it argue what the dissenting opinion does, that Chevron interpretation ambiguity provides an affirmative source of legal authority to preempt state laws. And I would personally argue that it does not exist. If you want to preempt the field, Congress can do it. The key word in that sentence being Congress. Congress does things by passing law. Agencies cannot just from thin air say that we can preempt the field without statutory authority. So, I'm glad that there's some limits to the Chevron doctrine after all. Second, the dissenting opinion fails to explain how the Commission's interpretive authority under Chevron to classify broadband as a Title I information service could do away with a sine qua non for agency preemption, a congressional delegation of authority either to preempt or to regulate. Sine qua non means that which without. Basically means something that is essential to. So it just means essential if you want to put it in non-Latin. Congress expressly fenced off from the Commission's reach or regulatory intrastate matters, including matters in connection with intrastate services. It is also Congress that chooses to house affirmative regulatory authority in Titles 2, 3, and 6, and not Title I. So the FCC has some affirmative regulatory authority according to laws that, again, Congress passed. They have affirmative regulatory authority in Titles 2, 3, and 6. So before, when they regulated this under Title II and said there was this thing called net neutrality, they could do that because Congress said you had the authority to regulate in that area. But then they switched it to Title I. And they said, oh, now it's just an information service. And Congress said, well, if it's Title I, you don't have affirmative regulatory authority. And the FCC says, yes, we do, because Chevron. And finally, a court said, no, you don't. So I'm once again glad there's a limit somewhere. And it's Congress to which the Constitution assigns the power to set the metes and bounds of agency authority. Yeah, that's what I thought when I learned from, I'm just a bill. I'm sitting here on Capitol Hill. Congress makes laws. That's kind of what I learned. Especially when an agency's authority would otherwise trample on the power of states to act within their own borders. So to work here, the agency's interpretive authority would have to trump Congress's calibrated assessment of regulatory authority in the Communications Act. In other words, for FCC, for you to win, your power would have to be greater than Congress's. That's not happening. Yeah, I'm with you, Evil Coleslaw. The very fact they switched back to Title I is what torpedoed their whole line of argument. Does make me smile. It's like, it's basically the too clever by half problem. When you're too clever by half, it's like, we're going to do this, and it comes with all these consequences you didn't see. Yeah. Now, one would think that the FCC's lawyers, general counsel, would have, brought that to their attention, but they were probably in such a rush to strip out the Title II authority, they just didn't pay attention to it. I bet one of their lawyers did bring it to their attention. I bet they ignored it. Yeah. But that cannot be right. Well, that's what I thought. No matter how desirous of protecting their policy judgments, agency officials cannot invest themselves with power that Congress has not conferred. Right. And nothing in Chevron rewrites or erases that plain statutory text. The dissenting opinion invokes two cases discussing implied preemption arising from different agencies' decisions to forego regulation under different statutory schemes. It first cites Arkansas Electric Cooperative versus Arkansas Public Service Commission, in which the Supreme Court observed that a federal decision to forego regulation in a given authority may imply an authoritative federal determination that the area is best to be unregulated. The court went on to conclude that the relevant statute did not in fact imply such a determination, and so state regulation issue was not preempted. At best, Arkansas Electric sets up one version of the question, but it gets the dissent no closer to its preferred answer, that here, Congress delegated to the Commission the authority to give sweeping preemptive effect to whatever policy determination underlay Chevron Step 2 interpretation of offer. In a second case, Ray versus Atlantic, the Supreme Court described the preemptive impact implied by the failure of federal officials affirmatively to exercise their full authority under the statute that the court had already recognized as delegating regulatory power to the agencies. Those cases do nothing to empower the Commission to engage in express preemption in the 2018 order. See oral argument. Commission, quote, no, Your Honor, it's express preemption. You can't do that. You can't do that. In either case was the source or existence of statutory authority for the agency to preempt state regulation at issue, nor do those cases speak to a statutory scheme in which Congress expressly marketed out a regulatory role for states that the federal agency had attempted to supplant. So again, when Congress set this thing up, they set it up with some power to the federal government and some other things where the state could regulate. So they said, as to these issues, these are state issues. As to these issues, these are federal issues. These are the kind of things that Congress gets to do. And if they want to preempt the field, they can do so if they do so clearly. They said, for Title II, we are preempting the field. If it's Title II communication, we're preempting the field so we can have a uniform regulation. But information services, states, you can deal with that. We don't want a piece of that. So, yeah. If Congress wanted Title I to vest the Commission with some sort of dormant Commerce Clause-like power to negate state statutory and sovereign authority just by washing its hand of its own regulatory authority, Congress could have said so, but they didn't. They said the opposite of those things. Third, the dissenting opinion's effort to discern Congress's delegation of preemption authority in Chevron and Brand X does not work either. The dissenting opinion acknowledges its theory of Chevron preempted authority derives entirely from the ambiguity in the word offer, a word that's buried in a definitional section in a non-regulatory part of the statute. So let's just take pause that the FCC is trying to gain all its authority to do this from one single word in a definition section. All the FCC's regulation that they're trying to do now with preemption all comes down to literally one word, the word offer. That's the magic word, according to the FCC. From that word alone, they have all the power to preempt the field because of offer. It's magic. The court disagrees, and so do I. Who cares what Congress says? We have Chevron. I'm with you, evil triple one, man. That seems to be the mode of things. The word offer means that we have deference. Okay, no you don't. Go away. To be sure, Chevron and Brand X together confirm the Commission has interpretive discretion to classify broadband as either an information service or a telecommunications service. Congress, in other words, granted an interpretive statutory fork in the road and gave the Commission the authority to choose the path. But the Commission's power to choose one regulatory destination or the other does not carry with it the option to mix and match its favorite parts of both. That's a nice bit of burn. The dissenting opinion's defense of the preemption directive makes the mistake of collapsing the distinction between the Commission's authority to make a threshold classification decision and the authority to issue affirmative and state-displacing legal commands within the bounds of the classification scheme the Commission has selected here, Title I. The agency's power to do the former says nothing about its authority to do the latter. Chevron, after all, is not a magic wand that invests agency with regulatory power beyond what their authorizing statutes provide. I just want to have that tattooed on me. That's such a good line. It's like I just want to take that line and just stamp it over and over again on every legal brief from here to the end of the world. I don't even care what the case is. I don't care if somehow I get involved in a murder case. I'm just quoting this line. I don't know how it's relevant. I'm throwing it in there somewhere. Chevron, after all, is not a magic wand that invests agency with regulatory power beyond what their authorizing statutes provide. Amazing concepts at work here, folks. Wow. Who would have thought Congress gets to decide what laws are, not agencies? That's what I thought. Instead, the point of Chevron was simply to draw lines between the courts and administrative agencies respective to their roles in interpreting ambiguous statutes. The dissenting opinion's theory of Chevron preemption, in other words, takes the discretion to decide which definition best fits a real-world communication service and attempts to turn that into a subsidiary judgment into a license to reorder the entire statutory scheme to enforce an overarching nationwide regime that enforces its policy preference underlying the designation choice. Nothing in Chevron goes that far, and doing here so would turn every exercise of Chevron Step 2 interpretation into a bureaucratic blunderbuss. That's a great word right there. Bureaucratic blunderbuss. For those of you who don't know what a blunderbuss is, it's a very antique kind of shotgun. It was a very inaccurate shotgun, so it just basically scatters things everywhere. That's a great use of word. Doing so here would turn every exercise of Chevron Step 2 interpretation into a bureaucratic blunderbuss capable of demolishing state laws across the nation anytime the agency fears that state regulation might intrude on regulatory or deregulation ethos. Wow, that's some pretty strong language to be. That's spicy language. I like it. The Supreme Court has made very clear that Chevron does not have that much muscle. Congress, the court has explained, does not alter the fundamental details of a regulatory scheme, let alone step so heavily on the balance of powers between the federal government and the states in vague terms or ancillary provisions. It does not, one might say, hide elephants in mouse holes. Yes, if they're going to preempt, they have to be pretty explicit about it. They don't do it subtly. They don't do it in one magic word of offer. I'll go back up to the top and find out who wrote it when we're done. I don't know who wrote it, but we'll find out later. It would be ironic if it was the chief judge who's that was the Supreme Court nominee. It'd be ironic if it was that guy. Merrick Garland was the name I was looking for. It'd be ironic if it was Merrick Garland. We'll find out. We'll read it later. And that principle is well settled limitation on Chevron. Congress does not generally hide Congress does not generally hide elephants in mouse holes, and we think it utterly improbable that Congress intended to authorize the EPA's interpretation by creating a list of several hundred toxic chemicals. The mouse hole, in short, cannot be the wellspring of preemption authority that the Commission needs. Doubtly so here when the Supreme Court has specifically held the Commission's desire to best effectuate a federal policy must take a back seat to Sections 152B's assignment of regulatory authority to the states. Anyhow, that's kind of casual for a court just to say anyhow, but That's what it says. Anyhow, the argument that the commission needs to save its classification decision from becoming meaningless still does not work. If a commission can explain how a state practice actually undermines the 2018 order, then it can invoke conflict preemption. If it cannot make that showing, then presumably the two regulations can coexist as the FCC Act envisions. What matters for present purposes is that on this record, the Commission has made no showing that wiping out all state or local requirements that are inconsistent with the order approach is necessary to give its reclassification effect. And binding Supreme Court precedent says that mere worries that the policy will be frustrated by jurisdictional tensions inherent in the Federal Communications Act does not create preemption authority. It's unclear what tensions they're referring to, since internet services of these kinds typically run within state lines. So, whatever. For those same reasons, the dissenting opinion's concern that the most draconian state policy trumps all else is a straw man. In vacating the preemption directive, we do not consider whether the remaining portions of the 2018 order have preemptive effect on their principles of conflict preemption or anything implied by the preemption doctrine. Much like the dissenting's opinion effort to wring out of the Arkansas Electric and Ray a source of preemption authority, the dissenting opinion's suggestion that the court's decision leaves no room for an implied preemption confuses the scope of the commission's authority to expressly preempt with its potential implied preemptive effect of the regulatory choices the commission's made that are within its authority. So yes, you get to choose, but you're bound by those choices. You made your choices, lie in that bed, sir. Fourth, the dissenting opinion's reliance on the Eighth Circuit's opinion in Minnesota Public Utilities Commission versus FCC is misplaced. That opinion enumerates the discrete question it purports to answer, none of which was whether Congress delegated to the Commission the authority to preempt. The Eighth Circuit decided only whether the Commission's order was arbitrary and capricious because it determined it was impractical or impossible to separate the intrastate components of voice-over IP service from the interstate components, or because it determined state regulation of voice-over IP conflicts with federal regulatory policies. This set of inquiries does not resolve the purely legal question of the source's commission's authority, asserted preemption authority here. Hello, Riley. How are you doing? The dissenting opinion concedes the point. Dissenting opinion acknowledges that legal authority was not formally at issue. The dissent nevertheless suggests that the Eighth Circuit's decision upholding as neither arbitrary nor capricious the Commission's finding of facts essential for application of the impossibility exception implies that, had the court actually considered the question of whether the Commission had the legal authority, it would have disagreed with us. But the Eighth Circuit's silence on that question leaves us with nothing to answer. Yeah, that's a bit of a strange thing to say. Like, if the Eighth Circuit had reached this question, they would have reached this conclusion. It's a bit of a logistical reach, but okay. At bottom, the Commission lacked the legal authority to categorically abolish all 50 states' statutorily conferred authority to regulate intrastate communications. For that reason, we vacate the preemption directive. And because no particular state law is at issue in this case, and the Commission makes no provision-specific arguments, it would be wholly premature for us to pass on the preemptive effect under conflict or other recognized preemption principles of remaining portions of the order. In other words, states, you go on and have your net neutrality doctrine in your states, and the federal government can bite it. Despite the Commission's failure to adequately consider the 2018's order impact on public safety, pole attachment regulation, and lifeline program, we declined to vacate the order in its entirety. When deciding whether to vacate an order, courts are to consider the seriousness of the deficiencies and the disruptive consequences of an interim change. Here, the factors weigh in favor of remand without vacating. First, the Commission may well be able to address on remand the issues it failed to adequately consider. Good luck with that. But because the Commission's preemption directive, see the 2018 order, lies beyond its authority, we vacate that portion of the order, purporting to preempt any state or local requirements that are inconsistent with the deregulation approach. So yes, Commission, you can take another stab at these other things, but as to your preemption authority, over. For these reasons, the petition to review is granted in part and denied in part. So ordered. Oh, so beautiful. Let's see who wrote this thing. Now I have to scroll back up 150 pages to get back to the authorship. Now, there's an easier way for me to do this. Let's see. Who wrote it? So many people. So, senior judge. Yeah, it was per Curran. So it doesn't say who wrote it. Williams was in dissent. So it was one of Millett and Wilkins. So we don't know who wrote it because it was issued as a per Curran. So they hid the authorship. So Millett and Wilkins, I guess, joint authored it or something. So maybe it's a joint effort, joint writing. So one of those two guys, or maybe in combination, wrote it. So yeah, we don't know for sure because it was issued per Curran. But oh well. Between them, though, they obviously got some writing chops. I mean, it's not surprising that they co-teamed wrote it, right? It's 186 pages. So, you know, it's not surprising that they spent some time. Yeah. No, the portions that we read were the portions we care about when it comes to net neutrality. The other parts, just to go through here, they spent some more time on brand X, spent some time on DNS catching, spent some time on dealing with the classification. There was a lot of can they change the classification from 2 to 1? Short answer, yes. Mobile broadband classification, do we care? Not really. Some of the different authority, arbitrary and capricious challenges, public safety. There's these other things dealing with other issues that we don't really care about in preemption. So we did everything we cared about. So I'm happy. All right. Let's do this case, I think. I'm still debating if I want to do the case where the police shot the dog. It's kind of pressing. Yeah, I think I do because, you know, law is depressing sometimes. So we're going to do some depressing law now. Yeah, I was surprised, you know, you always worry when these cases that, you know, who's going to win the day, but Mozilla et al. Won. You saw how many people were signed on this brief, though. Mozilla is just like one people. There's like a lot of people that were involved in this. All right, let's do this case. All right. Warning to the chat. A dog is going to get shot by a police officer. They're going to deny qualified immunity, though, so the officer is going to be held responsible for this. So just FYI, it's about to get a little unfriendly in here. For our case, we have the United States Court of Appeals for the Sixth Circuit in the case of Deshauna Richards and Eddie Harris versus the city of Jackson, Michigan, and Matthew Peters, who is a police officer. This case actually denies qualified immunity to a police officer. In this case, a police officer went into a home and shot a non-aggressive dog. The Court of Appeals is addressing the issue of qualified immunity and decides that it is not qualified immunity under the circumstances of this case. So let's read it and see what the court had to say about this and see that cops do occasionally skirt past the qualified immunity doctrine. It is undisputed that Officer Matthew Peters had no warrant, exigent circumstances, or consent to enter the residences of plaintiff Deshaun Richards and Eddie Harris on November the 28th, 2014. But when Peters approached the front door, which Peter claims he believed would lead to a common area, even though the plaintiff's door was clearly marked with an individual house number and had its own mailbox and doorbell, he opened it without knocking and walked inside. Once inside, Peters announced his presence, which prompted the plaintiff's pet dog, Kane, to run down the stairs and growl at the officer who was inside the home. Harris testified that although Kane was well trained and did not bite or lunge at the officers, Peters shot Kane as soon as the dog reached the bottom of the staircase. Richard and Harris brought this cause of action against Peters, alleging that he unlawfully entered the home and shot their dog in violation of the Fourth Amendment and Michigan state law. Peters moved for summary judgment on the ground of qualified immunity and Michigan governmental immunity, and the district court denied the motion as the plaintiff's Fourth Amendment claims and state law claims of conversion and gross negligence, and we affirm. In 2014, Deshaun Richard, Eddie Harris, and their pet dog Kane Lee Cheney, known as Kane, dog with 3 names, lived together at 513 South Blackstone Street in Jackson, Michigan. Richard bought Kane in 2009, and Richard and Harris shared responsibility for Kane over the 5 years that follows. Harris trained Kane, and Richard fed and cared for him. Richard and Harris described Kane as a well-trained American Pit Bull Terrier who had never displayed aggression towards other animals or people. On November the 28th, 2014, 2 police officers arrived at the address for reasons unrelated. On November the 20th, 2014, a probate judge had ordered a man named Dante Cox to report to the Alliance Health Hospital as he failed to pick up his prescribed medication. I'm assuming here that the individual named here had an order to take medication for some sort of court order. So, obviously normally picking up medication is not a violation of law. I'm assuming that this guy was under court order for psychiatric medication or something similar to that. If Cox did not appear at Alliance Health, the order stated that police officers would take Cox into protective custody and transport him to the hospital. When Cox failed to appear, the Jackson Police Department dispatched the officers to look for Cox at several addresses in Jackson, including at 511 and 513. Cox did not live at 513 Blackstone in 2014, and it's unclear from the record whether he had ever lived at that address. The officers began looking for Cox at the addresses provided by dispatch, which led them to the plaintiff's address. Upon arriving at the address, the officers found the 2 units were part of the same building. Each unit had a separate door on the exterior of the house, and each door was conspicuously labeled with a single distinct address identifying the residents inside. Each door was also accompanied by its own mailbox, and the door marked 513 had its own doorbell as well. One officer went to the door labeled 511, and the other officer went to 513. The officer knocked at 511, waited, and did not receive a response, so he did not enter. The other officer, in contrast, approached the door at 513 and walked inside without knocking or ringing the doorbell. Peters admitted that he had no search warrant, no consent, and no exigent circumstances that would have permitted him to enter the home. But Peters contends the front door was slightly ajar, and there was no solid door behind the screen door, so he presumed the door led to a common front entrance for multiple apartments, despite acknowledging that only one house number was listed on the door. In contrast, Richards and Harris testified the door was not a common entry. Instead, they contend Peters walked through the front door of their home, a door that did not provide entry to any other unit except theirs, as indicated by the address marked on the doorway. Both the testimony and multiple photographs of the property contradicted the officer's description of the door. There are actually 2 doorways at the entranceway, the screen door that Peters described, as well as a second solid white door immediately behind the screen door. Harris maintains the screen door was closed before Peters entered the home and heard the screen door creak open upon entry. The audio recordings from Peters' body cam microphone captures the sound consistent with the creaking that was described. Upon entering the doorway, Peters saw a small foyer, a flight of stairs, and an additional door on top of the stairs. The door at the top of the stairs opens into Richards and Harris's living room, where Harris was playing a video game with Richards' younger brother. Kane was lying nearby. When Harris and Caldwell were playing video games, they heard the screen door creep open and heard footsteps in the doorway, alerting them that someone was inside the home. Standing inside the foyer, Peters knocked in the interior wall of the apartment. After the knock, the audio recording from Peters' body microphone captures Harris yelling from the living room, "Who is this?" Peters responds, "Police." Right after Harris yells and Peters responds, the audio recording captures the sound of Kane running and growling for 4 seconds. Peter then contends that he said, "Get your dog," but Harris contends he could not hear Peters say anything. The audio recording captures Peters saying something dog, but the recording makes it difficult to discern the full quote or how loudly Peters was speaking. Kane continues to make noise, though it's unclear whether the sound is running, growling, or some combination of the two. Within 2 seconds of Peters saying something dog, the audio recording captures him shooting and killing Kane. What the audio recording does not capture, and what is hotly contested, is whether Kane, Harris, and Peters were doing in the 6 seconds between the time Kane began running from the living room and the time which you saw it. Both Harris and Peters agree Kane ran down the stairs and growled, but from there, the witnesses to the shooting provide differing stories. Harris testifies that Kane began running down the stairs to prevent Peters from coming up the stairway, because Peters was trying to creep in and creep upstairs without saying nothing. At the time Peters shot Kane, Harris contends that he was going down the stairs to get his dog, but Peters fired the shots before he could reach Kane. Harris testified that Peters shot Kane as soon as Kane got to the bottom of the stairway. In contrast, the police officer wrote in his police report that Kane immediately ran down the stairs, came directly to his feet, and began growling, snarling, and biting at his feet and ankles. Peters wrote that he yelled for someone to get the dog and kicked it, but one kick set the dog back against the bottom of the stairs only to have it charge back and again biting his leg. Presumably, there would be some bite marks on his leg. There would be some medical testimony of evidence of these bite marks, right? He's saying he's bit and scratched him. So surely there's going to be a medical report that's going to back this up, I'm sure, right? Let's wait to see where the medical report is of the bite marks on the leg. I mean, we're going to see that, right? I'm sure we are. Peters later testified he did not try to exit the apartment during the encounter. And while he's sure at some point he could have exited the apartment, he did not feel he had time to exit after yelling for someone to get the dog. Peters contends that after he yelled, Harris appeared at the top of stairways, ran a third of the way downstairs, and started yelling at Peters, though the audio recording does not capture it yelling. Peters testified that Kane returned between Peters' legs a second time after being kicked and shot Kane at that point because he believed Kane was going to bite him. Costley, the officer who was initially positioned outside 511, entered the plaintiff's residence after hearing Peters' voice come from inside the unit. The police report states that at the time he entered, Peters was backed into the far corner of the small foyer area, and Kane was at his legs, growling and barking in a vicious manner. Costley wrote that Peters attempted to push the dog away with his foot, and Kane moved back, but immediately began advancing towards Peters again, while continuing to grow and bark aggressively. The record is also unclear about the size of the foyer and Peters' location at the time of the shooting. The foyer is located between the front door and the stairwell that leads to the living room, but none of the witnesses or testimony or photographs in the record provide a clear estimate of the dimensions, and the officer's account regarding Peters' location within the foyer differ. Peters repeatedly states in his deposition he was standing just inside the door, but Costley testified that when he entered the plaintiff's home through the same door, he was backed into a corner. Was it with cops and slightly ajar front doors? Well, I think it might be possible. I'm just saying, guys. But bear with me. Come in close. I think it might be possible that cops occasionally fudge the truth a little bit. I think that might be a thing. Just saying. How you doing, man, Tobin? After the shooting, the audio recording captures Harris saying, "Why you shoot my dog, man?" Peters says, "Because he's biting me." Again, we're going to see medical testimony. We're going to see the dog dribble. We're going to see the closed torn. We're going to see the bite marks. We're going to see the ER report, right? That's going to come up any second to validate this testimony, right? But when deposed, Peters admit that Kane never bit him. Oh, man. Oh, the cop kind of may misrepresent the facts a little bit. Wow. I can't believe it. Terry testified Kane was biting him, but did not make physical contact with his leg. Oh, well, I guess that explains why we didn't see that medical report after all. Harris also contends that Peters was flippant and even laughed during their conversation after the shooting. The Peters testified that he did not recall having laughed. Personally, I believe the cops probably laughed. On September the 29th, 2016, Richard and Harris brought a cause of action against Peters, alleging Peters unreasonably searched their home and seized Kane in violation of the Fourth Amendment and Michigan tort law. Peters moved for summary judgment on grounds of qualified immunity and Michigan governmental immunity. On August 27, 2018, the district court denied the motion for conversion and gross negligence claims. Peters finally a notice of appeal. So conversion is the civil equivalent of theft. Basically means you've taken property without permission. That's the civil term for it. What gets me is cops will tell you police dog biting a suspect is not that big a deal, and yet they have to shoot a dog if it comes too close. Yeah, that's pretty astute observation there. It's not a big deal when the trained police dog does it, but if the owner's dog does it, hugest deal ever. Yep, there might be it might be, guys. Again, I come in real close. It might be that the cops don't necessarily always apply the rules to themselves. Just in analyzing whether an official is entitled to qualified immunity, we must make two determinations. First, where the plaintiff have created a genuine dispute of material fact regarding the official deprived them of a constitutional right, and second, where the right was clearly established that such a reasonable official would have known his actions were unconstitutional. Yeah. Courts can address these in any order. In undertaking the inquiry, we accept the view most favorable to the facts of the plaintiff for the purpose of appeal. Here, the district court denied the qualified immunity for the two Fourth Amendment claims. First, the claim of warrantless entries in the home constituted an unreasonable search. And second, the claim that shooting and killing the dog constituted unreasonable seizure. We address these each in turn. In determining whether the district court erred in denying the officer qualified immunity for entering the home, we begin with the question of whether the plaintiffs have presented a genuine dispute of material fact regarding whether the entry into the home deprived them of a Fourth Amendment right, and then analyze whether that right at issue was clearly established. Well, let's see. Is there a clearly established right that to prevent the police from entering your home with no warrant, no exigent circumstances? I'm going to have to say yes. I seem to remember reading that right once. I seem to remember that it was, I don't know, Amendment 4 of the U.S. Constitution comes to mind. That seems to be pretty well previously established, just off the top of my head. The Fourth Amendment protects against unreasonable searches of an individual's home. The Supreme Court has recognized physical entry of a home is the chief evil against the wording of the Fourth Amendment is directed. In terms that apply equal to seizure of property and seizure of persons, the Fourth Amendment has drawn a firm line at the entrance of the house. The home is special. The Supreme Court has taken this threshold seriously, making clear that any physical invasion of the home by even a fraction of an inch is too much, and there's certainly no exception to the warrant requirement for the officer who barely cracks open the front door and sees nothing but the non-intimate rug on the vestibule floor. So in other words, the very moment that you open the door with the creaking noise, you violate the Fourth Amendment. Amazing concepts at work. Peters does not argue that he had a warrant, consent, or exigent circumstances. Instead, his argument turns on whether he had entered the plaintiff's home at all. Really? It's pretty clear he did. I mean, okay. Pierce claims he reasonably believed the front door led to a common entryway shared by multiple residences, and he argues that individuals have no exceptional, objectively reasonable expectation of privacy in an unlocked and common hallway entrance and stair of their duplex. I mean, I would argue they do. They have a shared interest in it with the other people of the duplex, but still, even the shared entryway belongs to both them collectively. It's not the police's. I mean, by that argument, any random person could come into the shared area of a duplex and it would be okay, which doesn't even begin to make sense in my mind. Pierce's position elucidates a critical factual dispute whether the foyer was in fact a common area. The plaintiffs vigorously dispute the foyer was a common area, and the record supports it. The district court rejected the suggestion that it was a common area, finding each unit had its own door and plaintiffs were the only residents of the building who had access to it. We agree the plaintiffs have demonstrated that they entered the home and not a common area. The remaining argument is that even if he entered the home, he had restricted his movement to the area of the apartment that was generally accessible to visitors of the property is unpersuasive. Yes, it's generally accessible to visitors who are invited. Who are invited. If I am, like, for example, a door-to-door salesman going door to door, and I open the door and I walk into your foyer to say Avon calling, you're going to have a problem with that, as well you should. Richard's deposition makes clear that although the living room and bedroom were on the top of the second set of stairs, everything inside the door that Peters Beach is part of the apartment. Once Peter entered the plaintiff's home, it did not matter whether he was in the front hallway where they accepted visitors, again, who are invited, or in their bedroom. Any physical invasion of the structure of the home by even a fraction of an inch is too much. I agree. So under the argument, the cops could come anywhere I've invited someone and it's no biggie. I guess so. I mean, that seems to be the implication. I mean, if you have an entryway of your home, and apparently the cops can come in there and presumably anyone else, right? Because you have no privacy interests in the foyer of your home, because lots of people come in the foyer of your home. I don't know what to tell you. The argument's wrong. I grasping at straws is all I got. Even assuming entry into the plaintiff's home was unconstitutional, Peters argues he reasonably believed the foyer was an entrance to the common area. An officer who acts on that mistaken but reasonable belief is entitled to qualified immunity. This court has held that a government employee will be shielded from liability so long as the employee acted under an objectively reasonable belief that his or her actions were lawful. Thus, at this stage of litigation, we must determine whether a jury could reasonably find the belief was not objectively reasonable. Pierce contends that when he entered through the unlocked door in a multiple occupant building, he believed the door would lead to a foyer for which he could access the doors to multiple interior units. In his deposition, Pierce testifies that in Jackson, there are countless large homes with multiple apartments inside of large buildings, mostly which you have to go to get inside the individual apartments, be it 1, 2, 3, A, B, or C, and in his experience, the address markings on these exteriors of buildings would not always indicate there were multiple units. But Pierce also agreed he had received no information from dispatch indicating that such subunits existed in this apartment, and that he was not asked to look for an individual in 513 A, B, or C. He simply told Cox might be at 511 or 513, each of which had its own door and address marking on the exterior of the home. The fact that some houses in Jackson have this design does not preclude a jury from finding that Peters was unreasonable, assuming this house would have such a feature. Again, with the cops with the mistaken door, we're back to the Amber Geiger trial all over again with the cops with the mistaken door, man. Lord. I guess this happens more than you would expect or something. I wonder if this one also had a bright red floor mat. The photographs of the home's exterior further undermine the unreasonableness of the belief. The clear address markings, individual mailboxes, and doorbell outside the door cut against the idea the front door led to a common area. After considering all the evidence, the district court found that whether it was unreasonable for the officer to assume plaintiff's home consisted of multiple dwelling units and he unlawfully entered the home presents a genuine issue of material fact, which should be determined by the fact finder. Excuse me. We agree. Because there is a genuine dispute of material fact regarding whether the officer's belief that he not entered the plaintiff's home when he walked through a doorway was reasonable, we affirm the denial of qualified immunity. Yeah, you go to a jury and you try to convince them it was reasonable. Good luck with that. Let us know how it turns out. In determining whether the district court erred in denying the qualified immunity for shooting Kane, we began with the question of whether the right was clearly established on the 28th of November of 2014, and the address of whether the plaintiffs had a genuine issue of material fact regarding whether the officer seized Kane in violation of the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures of an individual's property. The court has acknowledged that there's a constitutional right under the Fourth Amendment to not have one's dog unreasonably seized. In deciding the contours of that right, we began with the premise that a seizure becomes unlawful when it's more intrusive than necessary. In determining whether a seizure of a dog was more intrusive than necessary, we reiterated the holding that court must balance the nature and quality of the intrusion of the individual's Fourth Amendment interest against the importance of the governmental interest alleged to justify the intrusion and determine whether the totality of the circumstances justifies the seizure. Yeah, Evil Coleslaw, I think you're right. Where there's no knock warrant and went in the wrong house and killed someone. I think you're right. I think that's exactly right. I think that's true. I'm now depressed. Fantastic. Well, it didn't help that we were reading the shooting the dog story, so depression was pretty much guaranteed. Let's carry on. In Brown, we conclude that shooting a pet dog is a severe intrusion given the emotional attachment. But we also found that ensuring officer safety is particularly important governmental interest. After balancing these interests, we found that police officers' use of deadly force against a dog while executing a warrant to search a home for illegal drug activity is reasonable under the Fourth Amendment when, given the totality of the circumstances and viewed from the perspective of an objectively reasonable officer, the dog poses an imminent threat to the officer's safety. We define the requisite imminent threat as an immediate, real threat to one's safety that justifies the use of force in self-defense, or the danger resulting from immediate threatened injury sufficient to cause a reasonably and prudent person to defend him or herself. In defining the right at issue, we note that a large number of our sister circuits have already concluded that the use of deadly force against a household pet is reasonable only if the pet poses an imminent danger and the use of force is unavoidable, and that every circuit to consider the issue has concluded that the unreasonable killing of a dog constitutes an unconstitutional seizure. Accordingly, we determined the right not to have one's dog unreasonably seized was clearly established, and we proceed to determine whether the seizure at hand was reasonable, and we see no reason to depart from that here. Can they even recover that much? Dogs aren't worth that much? I mean, I don't know. It's the principle of the thing. And presumably they can sue for the emotional attachment too. Although that isn't being raised here, but I would think that they could sue for the emotional issue. But it's the principle thing. And presumably you could sue for like the requisite training. You could sue for like things that you would need, but yeah, maybe it's the principle of the thing. I don't know. But maybe there's some emotional damages issues that are possible here too. Despite this court's holding in Brown, Peters argues the right issue was not clearly established, neither of which is convincing. First, the officer argues that Brown was issued in 2016, which is later in time than the conduct issue and therefore cannot suffice. This argument misreads the case, which we unequivocally stated that the constitutional right under the Fourth Amendment not to have a dog unreasonably seized was clearly established in 2013. So yes, they're citing in 2016 that says it was established in 2013. So yeah, because the right was clearly established in 2013, it was also clearly established in 2014. Yeah, of course. If they violated the Fourth and Fifth, can they recover for just those violations? Yeah, I mean, presumably. They can recover for any damages that they can lay claim to, presumably. So they should be able to lay claim for it. Yeah. Second, Peters argues that he could not have been expected to anticipate our recognition of the case that unlicensed dogs are property under the Fourth Amendment. Really? You couldn't be expected to understand dogs are property? Okay. How the officers argued they shot Kane because he believed Kane was unlicensed and that they had no property interest in an unlicensed dog, this argument might have some force. But Peters gave no indication that he knew or even considered when Kane was unlicensed at the time of the shooting. Thus, the officer's ability to anticipate this court's ruling in Smith has no bearing on whether Peters should have been known that his actions were unconstitutional. We must next determine whether the plaintiffs have raised a genuine dispute of material fact regarding whether Kane presented an imminent threat that justified the decision. At this stage of the case, we're required to view the facts in the light most favorable to the plaintiffs, even where only a genuine dispute is created by the plaintiff's uncorroborated testimony. Thus, for the purposes of appeal, we must assume that when Peters announced his presence from inside the home, Kane ran down the stairs and growled but never advanced past the foot of the stairwell. That Kane did not lunge or bite at Peters, and Harris was on his way down the stairs to get Kane at the type shot. So yeah, on the motion to dismiss, we assume the facts in light of the non-moving party. So we're assuming that the people are right and all the things they say are true. Of course, we'll have to prove that at trial, but we're assuming it's correct in order to get to the motion to dismiss. If everything they say is true, they have a case. All right. We begin our analysis of whether a seizure in this case was reasonable with a closer look at Brown. The specific facts in Brown led this court to conclude that no genuine dispute of material fact existed regarding the reasonableness of shooting two dogs. In Brown, officers were executing a raid on the home of a suspect who posed a serious threat to officer safety. Officers knew the suspect had a criminal history, used firearms, and had deep ties to a large, tightly knit gang. These circumstances placed the officers in Brown on a high alert going into the raid that other members of the gang could be in the residence and they could be armed and dangerous. No, fifth makes sense because fifth also deals with taking a property. So taking a property. So there's a seizure, and you could also make a takings clause issue under the Fifth Amendment potentially too. So I don't think your citing of the Fifth was completely unreasonable. Of course, the takings clause typically does with real property rather than personal property, but why not? Why not make a takings clause argument while you're at it for the Fifth Amendment? In Brown, it was also undisputed the dogs displayed some sign of aggression beyond growling. The dogs began lunging towards the windows as officers approached the front door. The 97 dog jumped the couch and lunged at officers again as they entered the residence, which prompted the officers to fire at the dog. This is again talking about the prior case of Brown, not the current case. Still, the dogs continued to obstruct the official's path in the basement of the home. Given the high risk presented by the suspect's firearm and gang activity, the officer's priority in securing the basement and conduct for a sweep for other potentially dangerous people in the home, the officers testified they could not safely accomplish this goal with both dogs being present. Despite having been shot once, the 97-pound dog turned the officers in the basement and started barking again, so another officer fired a round of shots, killing the dog. The 53-pound dog was also in the middle of the basement, barking at officers as they attempted to clean the area. The same officer who just shot the second dog when he saw it barking at the officers, and the second officer fired at the dog again when it began moving towards him. In determining that shooting the dogs was not unreasonable, in the prior case, we emphasized that those plaintiffs, in that case Brown, failed to rebut several undisputed material facts, namely that the large dog had lunged at the officer before they shot. The officers weren't able to safely clear the basement with both dogs there. The court also reiterated the suspect criminal's history and gang affiliations, the fact the officers had no time to plan for the dogs, nature and size of the dogs, and the fact the dogs were unleashed and loose in a small residence. Considering each of these factors as part of the totality of the circumstances, we found the plaintiffs failed to create a genuine dispute, a material fact regarding whether the dog was barking and lunging at the officers as they breached the entryway, posed such an imminent threat to the officers it was necessary to shoot the dog in order for them to safely sweep the residence and ensure that no dangerous people were present. The facts of Brown bear some similarity to the present case. Like in Brown, Peters did not know about the dog in advance and had no time to plan for how to handle the dog. Additionally, Kane was off the leash in what appeared to be a small area, but there are several meaningful differences. First, the level of aggression described in Brown is a common theme in cases where courts have found the seizure was reasonable. Taking the facts in the light most favorable to the plaintiff, Kane displayed a significantly lower level of aggression. Here, Peters' only reason to believe Kane presented an imminent threat was that he ran down the stairs and growled when an unknown person entered the home. As the district court noticed, this behavior is distinguishable from more serious displays of aggression akin to lighting or bunging because descending stairs, barking, and growling is naturally expected of a dog when a stranger enters a home. We do not hold today that a dog must bite an officer before he can fire a weapon, but a jury could reasonably find the absence of any aggression apart from growling is a factor that cuts towards unreasonableness in assessing the totality of the circumstances. Furthermore, the context of the seizure is dramatically different from that in Brown. Unlike the officers in Brown, Peters was dealing with only one dog, and here there was no intimation risk of there's no intimation of high-risk gang activity or a similar level of threat inside the home that required Peters to conduct a sweep for safety of this home. Rather than Peters had been dispatched to look for a man who failed to pick up medication. As discussed above, Peters did not even have a warrant to enter the home in question, let alone to conduct a thorough sweep of the premises. Relatedly, the questionable validity of the search distinguishes the case from Brown. Although the primary question in excessive force is typically whether the force used to effect the seizure was reasonable in the totality of the circumstances, not whether it was reasonable for the police to create the circumstances, this court has acknowledged that where the events preceding the shooting occurred in a close temporal proximity to the shooting, those events have been considered in analyzing whether excessive force was used. Because the audio recording suggests Peters' relevant conduct from the time he entered the home to the time he shot Kane, which occurred within 17 seconds, a jury could reasonably find that Peters unlawfully entered the preceding shooting the home as an additional factor cutting against reasonableness. Several additional unresolved facts suggest a genuine dispute of material fact remains. For example, the uncertainty in the record regarding the size of the foyer and the location in the foyer at the time of shooting makes it difficult to tell whether Kane posed an imminent threat. A jury could reasonably find that a growling doll standing several feet away from an officer does not present the same type of imminent threat as a dog who is lunging towards the officer. The record also contains no information about Kane's size. In Brown, this court looked to the nature and size of dogs, noting that the record demonstrated that the one dog was 97 pounds and the other dog was 53 pounds. In contrast, none of the police reports or depositions in the case even describe Kane as large or small. The lack of information about size matter, as a jury could reasonably find that a threat posed by a 30-pound dog is meaningfully less severe than one posed by 97 and 53-pound dogs. In light of all the considerations enumerated above, the lack of aggression beyond common dog behavior running downstairs and growling at strangers in the home, the absence of high-risk criminal activity, Peters' unlawful entry into the home, ministerial disputes in the record regarding the distance, and lack of any record facts regarding Kane's size or weight, we conclude the plaintiffs have a material dispute of fact. Do I want to cover Michigan governmental immunity? Let's see. Where am I? Page 15 and 17, it's only 2 pages. Sure, why not? Peters next argues that the district court erred in denying Michigan's governmental immunity on the plaintiff's state law claims of gross negligence and conversion. Michigan governmental immunity functions differently from intentional torts and torts that require only negligence, so we begin with the intentional tort of conversion and then proceed to the gross negligent claim. Richards and Harris alleged that Peters committed the intentional tort of conversion under Michigan law because killing Kane was a distinct act of dominion wrongfully exerted over the dog in denial or inconsistent with rights, and Peters' conduct approximately caused the injury. Michigan governmental employees are immune from intentional tort liability where they can establish that the employee's challenged act were undertaken during the course of employment and the employee was acting or reasonably believed he was acting within the scope of his authority, and the acts were undertaken in good faith, and the acts were discretionary rather than ministerial in nature. The parties dispute only the second element, where the jury could reasonably find that they did not act in good faith. The good faith requirement imposes a subjective test for governmental immunity for intentional torts based on the officer's state of mind, in contrast to the objective test for federal qualified immunity. Pierce argues that he acted under good faith, believing chicane was necessary to defend himself, but the plaintiffs contend that the actions were not taken in good faith, arguing the record evidence supports a finding that the officer took no efforts to bring a halt to his chain of unlawful conduct and ultimately led to the unjustified destruction of Kane and resultant wrongful conversion of the property. Because Peter knew or should have known that he was not permitted to enter the home, he knew he was unlawfully on the premises once inside, and instead of retreating or giving the person the opportunity to grab the dog, he maliciously executed the pet within 6 seconds. We believe the record supports a jury finding in favor of either party on this issue, and because it's a genuine dispute of material fact, we affirm. Richard and Harris also alleged that as police officers, Peters had a duty to perform his employment activities so as not to endanger or cause harm to plaintiffs, and he breached the duty with deliberate indifference and gross negligence without regard to rights. The officer contends that his intentional acts of entering the foyer and shooting the dog correspond to intentional torts of trespass and conversion, and gross negligence is not an independent cause of action when the underlying claim is an intentional tort. Peters is correct that Michigan has rejected attempts to transform claim involving elements of intentional torts into claims of gross negligence. But plaintiffs are barred from bringing gross negligence claims only if those claims are fully premised on alleged intentional torts. This court has sustained gross negligence claims premised on allegations the officers were grossly negligent in failing to follow certain procedures and statutory obligations, or the plaintiff can otherwise show the defendant owed them a duty of care. In Bell v. Porter, the district court upheld plaintiff's gross negligence claim based on officers' breach of similar duties to avoid foreseeable injury to plaintiff while investigating or pursuing legitimate police activity, and to avoid conduct or failure to act that's so reckless it demonstrates a substantial lack of concern for whether injury will result. Like in Bell, the plaintiff allegation of gross negligence here is based on the same incident as the intentional tort that Peters describes, but plaintiffs have adequately alleged an alternative basis for the claim. Thus, the allegation in the complaint that Peters breached his duty to perform his employment activities so as not to endanger or cause harm to the plaintiff is sufficiently distinct from the separately pleaded intentional tort. Finally, Peters argues his conduct was not the proximate cause of the injury. Really, it seems pretty proximate to me. You're the one who shot him. Because he argues Kane's aggressive behavior and Harris's inability to gain control also contributed. That argument is uncompelling. The Michigan Supreme Court has held a government official can only be deprived of immunity for gross negligence claims if his actions were one of the most immediate, efficient, and direct causes of injury or damage. Here, one of the most immediate, efficient, and direct causes of injury was undoubtedly the decision to fire the weapon. Thus, we affirm the denial of the motion, and for the foregoing reasons, we affirm. So that is the case of Deshaun Richard and Eddie Harris, and indirectly the dog Kane, versus Matthew Peters and the city of Jackson. So lessons learned here: if you do not have a search warrant or exigent circumstances, you can in fact not enter someone's home. That is not an okay thing to do. And once inside their home, you cannot just shoot their dog for any reason that suits your fancy. So this is going to go back to trial, and the jury will have to determine whether or not the officer was mistaken and whether or not his actions were reasonable. So at least both parties will get their day in court, and a jury will have to decide what damages accrue as a result of this. So we'll keep a watch of this and see what happens next. It was itchy scalp. Itchy, itchy, itchy. All right, so I have to resize this window. Can do this. Watch this. Yeah. All right. I need a drink of water. Hold on a second. Tell you what, seltzer's good stuff, man. Gotta get yourself club soda. It's good stuff. Yes, alienation of affection. Alienation of affection, North Carolina. We are going to discuss alienation of affection. Everyone's favorite tort. Yeah, need to lubricate the throat. Yes, exactly. All right. Excuse me. For our story today, we are covering a story out of North Carolina. Let's try that again. For our story today, we're covering a story out of North Carolina where a man's wife cheated on him and left him. But the husband was able to get some sort of measure of satisfaction because the husband sued the lover for stealing his wife and won an award of $750,000 from the lover of his wife who stole his wife away. This is called alienation of affection and is a tort recognized in North Carolina and a few other states. So we're going to read a little bit of this article, and then we're going to read something that gives a very good summary of this law so that we can understand some of its rationale. So let's get started. I'm pretty sure it's not beer, yes. I don't usually drink beer out of cans. I usually drink out of bottles. So... From Greenville, North Carolina, a Pitt County man has won $750,000 judgment against another man for alienation of affection for stealing his wife away. She originally told me she wanted a divorce because I worked too much. I wasn't around there and I worked too much. I started to talk about it as part of my mistake in the situation, but it was like a punch in the gut because I thought I had this trust for 12 years of love. Although adultery is sometimes romanticized, in reality, life cheating with someone married and causing their divorce is illegal in North Carolina and 6 other states. Hawaii, Mississippi, New Mexico, South Dakota, Utah, and North Carolina still hold on to alienation of affection. So I'm not sure how Hawaii got into this list, being a more left-leaning state, but it is on the list of places where alienation of affection is a recognized tort. Okay. Yeah, maybe. He wants to really love his wife to get $750,000. It makes the pain a little easier. I'll tell you what. I don't know, guys. Maybe before I'm debating whether or not to make this part of the video, and if I do, I'll say it again at the end of the video. But like, if you think about this from another frame of view, it's tortious interference with contracts, right? Because a marriage is a contract. It's a special kind of contract, to be sure, but it's a contract. So, like, if this were any other kind of contract, you'd be analyzing it under tortious interference. Like, so to me, it seems like this tort should be recognized everywhere because it's just basically interference with a contract. I mean, special kind of contract, but the fact it's special would seem to suggest it's more important, not less. So I don't know. I don't quite understand why, like, if tortious interference with contracts is generally de-recognized, why is this special? I don't know. Anyways. First Amendment right to try to break up marriages. Yeah. You are evil, Tribble, after all. So I thought what we do is we read an article that I found that very nicely summarized the law. So this is called an in-depth discussion of alienation, affection, and criminal conversation. So this is written by a lawyer, and I thought it presented a good summary of the law. So we'll read this so we can understand some of the law that goes into this issue. Alienation of affection and criminal conversation? Does it mean is this a conversation? Is this conversation? Criminal conversation? That's really what's called? All right, I'm skipping that. What elements do you have to show to make a claim of alienation of affection? The essential claims of alienation of affection are that the husband and wife have a marriage of genuine love and affection. The love and affection existed between the husband and wife was alienated and destroyed. The lover wrongful and malicious conduct was the contributing cause, and the alienation has caused damage. It's important to consider that these elements of the claim are tricky because of its very nature. First of all, what is genuine love and affection? How can a jury determine love and affection? First, it's very important to consider the elements of this claim are tricky because of its nature. What is genuine love? How can a jury determine whether love and affection existed? Does a third party have to have sex with the spouse in order to cause him or her and alienate the affection? How can you determine what is wrongful and malicious conduct, or the conduct was a controlling cause? What kind of damages are we talking about, and how can you put a dollar amount on the relationship lost? It's hard to pinpoint the definition of genuine love and affection. Alternatively, let's consider some factors that may tend to show when genuine love and affection did not exist. This element is incredibly important because it offers the strongest defense. For example, if the married couple had been counseling or discussed separation for many months or years prior, then it's likely one could argue that no longer existed genuine love or affection. While it's possible this is the strongest argument, there's some North Carolina case law that suggests otherwise. One case involved a married couple who had separated prior to the involvement. The separation was not important. The fact that the married couple had resumed their relationship was evidence they somehow managed to maintain the necessary genuine love and affection for the purposes of the claim. Other case law suggests that even if plaintiff had an affair during the marriage, then the genuine love and affection is still not negated for the purposes of providing that paramour's wrongful conduct led to the alienation of spouse's affection. That's pretty interesting. So if you have an affair, but you get back together, and then the other spouse has an affair and they leave you, you can still sue. So that's an interesting turn of phrase in North Carolina law. As you can see, these cases are very fact-specific. Thus, whether a marriage had genuine love and affection is ultimately a question for a jury, how we decide many of these issues. The element that love and affection between husband and wife is destroyed is typically clear if the married couple is separated or divorced immediately subsequent to the relationship with the cheating spouse. The lover's wrongful and malicious conduct was the controlling or effective cause. This element can be broken down to two parts. First, what is malicious or wrongful conduct? According to Black's Law Dictionary, every sovereign citizen's favorite dictionary, but still a valuable resource for those of us who know what we're doing, malice by definition is the intent without justification or excuse to commit a wrongful act. In cases of alienation of affection, malice is presumed if the act of seduction, or adultery is shown. However, other actions performed by the paramour may rise to the level of malicious and wrongful conduct. For instance, conduct such as excessive telephone calls to and from the plaintiff's spouse or scheduling secret rendezvous may be enough for a jury to consider the conduct malicious and wrongful if a jury determines the paramour knew of the potential harm. Second, to establish this element, one must show that wrongful acts of the defendant are the controlling or effective cause of the alienation, if there are other causes which may have contributed. Must the paramour have instigated the resulting alienation? Not necessarily. Affirmative conduct from the paramour will be sufficient. For example, in one North Carolina case, the paramour involved with plaintiff's spouse said to the plaintiff, "I'm sorry to have done this to you." What this was coupled with, evidence of a hotel reservation, is enough for a jury to find the paramour's conduct caused the plaintiff's spouse to alienate her affections from him. Moreover, there's no need to show the paramour was motivated by ill will towards the plaintiff. Finally, there's no need to show the spouse and paramour even had sexual intercourse in order to prove the alienation of affection. Nice. How are damages determined? I don't know. I guess you ask a jury what it's worth. How long you've been married and put a number. I don't know. Damages are typically defined as monetary compensation for a loss. There are two types of damages to be considered: compensated damages and punitive damages. Compensated damages are damages that compensate the plaintiff for the harm caused by the conduct. Generally, those damages will include expenses incurred for therapy costs, prescription medication costs, loss of services in the home for such as day-to-day chores, loss of spousal support, loss of consortium, which means loss of sexual relationships, so you can sue for loss of sex, outstanding, emotional distress, injury to the plaintiff's reputation, cost of litigation, for the divorce and other causes related. Punitive damages are damages intended to punish the defendant. For the question of punitive damages to be submitted to a jury in an alienation affection case, there must be evidence of circumstances of aggravation beyond the proof of malice necessary to recover for the compensation damages. These specific circumstances of aggravation include willful, wanton, aggravated, or malicious conduct, so the plaintiff must show evidence of malice. If the paramour and the spouse had sexual relationship, it's likely malice will be implied. Do you cite a hooker's rates in determining monetary damages for loss of sex? That is a hilarious thought. I don't know. It's a pretty interesting idea, though. You go figure out what the market rate for prostitution is and use that as a basis for damages. That's something evil, Tribble. You have a mind that's valuable in law. You're too good for this world. Become a lawyer. All right, where was I? Second, a plaintiff must show defendant aggravated the conduct. Some say the defendant poured salt into the open wound. Or are some specific circumstances of aggravation? Well, in one case, sufficient evidence of aggravation to justify punitive damages award existed where a plaintiff presented evidence that plaintiff's spouse and defendant had had sex at least 2 times. The defendant accompanied plaintiff's spouse when returning the children to custody of plaintiff. The defendant appeared unannounced at the front door of the marital home to ask plaintiff if they could be friends. And defendant arrived at the driveway of the marital home while plaintiff was visiting his children. Other circumstances that might suggest the circumstances have been aggravated by defendant's conduct may include defendant calling and meeting plaintiff's spouse hundreds of times while having knowledge of the marriage. I'm going to move to North Carolina and become a specialist in this field of law. I feel a calling, guys. You know, my parents' home is very, very near the North Carolina border. So I'm just saying I could move down there, become a North Carolina lawyer, and I could take on alienation and affection cases in Charlotte, man. It'd be awesome. Maybe I should change careers. I feel a calling. I could hire some PIs. They can go on stakeouts. It'd be great. Under North Carolina law, punitive damages are never awarded merely because of personal injury inflicted, nor are they measures by extent of injury. Rather, they are awarded because of outrageousness of the defendant's conduct. However, with outrageous conduct established, a jury may still not find defendant should be punished. Finally, in order to recover punitive damages, the jury must first award compensation damages if those damages are nominal. Then, depending on evidence presented, a jury can determine whether the evidence is sufficient to show punitive damages shall also be awarded. And I don't care about the other one, so we'll skip that. $750 made for one hell of a commission if you go on contingency. Yeah, if you go with a normal 30 to 40%, you're looking at a payday of $250,000 to $300,000 plus expenses. So, you know, $250,000 to $300 plus expenses. So many people get screwed out of this relationship. Yeah, I can hire Evil Tribble to investigate market rates. That's right. Yeah, I'm gonna hire a personal investigator, and your job as personal investigator. I know it's a tough job, but here's what I want you to do. I want you to go forth into the prostitution industry, and I want you to find out from firsthand experiences what prostitutions are charging. And I can write it off as a business expense. Wow. This is the potential here is mind-numbing, guys. I have to say, I'm kind of thinking about it a little bit. I know I'm joking, but kind of thinking about it a little bit. Patent law is a little dry, man. I never wanted to go into family law, but this is a whole new world, man. Scorned lovers are us. The Scorned Lovers Law Firm. We'll get back. We'll get back at your ex, no matter the cost. Man, too much fun. And that's great because you know what's going to have to happen, right? You know what's going to have to happen when I'm figuring out the charges for alienation affection. You know what has to happen, right? I have to put an expert witness on the stand. Which means I have to put one of these ladies on the stand. And of course, being a good lawyer, I have to sufficiently prep my witness so they know how to answer questions on the stand. So I can also charge my client for the prep time as an expense. Yeah. Wow. I'm going to give lawyers a bad name, guys. I'm just saying. This is happening now. Oh, man. So that is our story for the alienation of affection case from North Carolina and other states. So lesson learned here, I guess, if you're going to try to, if married women are your type, you may want to stay out of these states when trying to seduce them because you're just asking for damages to be held against you. So if your next convention is in Charlotte, North Carolina, and your type are married women, you just might want to stay away because it looks like it might be more trouble than it's worth. Just pro tips to the wise. My expert witness would be the pimp. They match the wife's description with a suitable partner. I mean, there's many ways to address this issue, guys. I mean, I just like the fact that I can bill my client for a third to 40% for my contingency fee and then expenses, and legitimate expenses might include such things as surveying the prostitution community to get an idea of rates of services for loss of consortium claims and getting them on the stand to testify. Yeah. And prepping their witnesses. Much prep time needed. Drive down to Rock Hill, South Carolina, do your dirty deeds, I guess. Well, guys, that's the end of the cases I wanted to record. Let's see now. Unless I want to do something about the MGM case. I don't really have anything to add about it except that it's settled. I'll come back to it if I need it. If I need another story, I'll record it later. And of course, I was going to do a story about this one, about the witness in the Amber Geiger trial who was murdered. So one of the key witnesses for the government in the murder trial of Amber Geiger himself was just recently murdered. So that's weird. The police say they have a suspect. Apparently it was a drug deal or something, but a man who was a key witness in the murder trial was fatally shot himself in the parking lot. So, yeah. He lived directly across the hall from Geiger. Or Brown. Yeah, so, yeah. Drug deal gone wrong is what they say. I heard that's what they said too, but the timing is suspicious, as I'm sure we can appreciate. So, yeah, so I don't know if I'm going to go so far as say cops did it, man, but timing is pretty suspicious, man. So I do have my skeptical hat on here a little bit. So I might do that story later. I might come back to that, but I'm not going to do it now. And I might come back to the MGM thing, selling for $800 million if I need another story. But you know, I don't know what to say other than they sold for $800 million. I guess I could discuss the legal stuff dealing with the tort, but that's all. All right. Anyways, that's all I have for today, guys. That's all I need. As always, if you like this channel, please like, subscribe, hit the bell, leave a comment, tell me you love me, give me love and support, encouragement, tell your friends. Oh, by the way, I now have a Facebook page. So actually, you can do me a favor. You can do me a favor right now. So it's facebook.com. I think it's /uncivil law, but I want to double check. Yes, it is. So it's facebook.com/uncivil law. It's a brand new page. If you have Facebook, if you just go and like the page, I'd appreciate it. All I'm planning on doing there, incidentally, is posting stories from here. So all there are right now are just the stories. I'm posting one a day. I'm using the Facebook page to run ads to promote the YouTube page, because there's not really like a good way to promote YouTube within YouTube, or at least I haven't found one. So all I'm doing is I'm posting the links from YouTube there, and I've only posted the last 3 days pages because I've only just created it. But I'm running like ads at $2 a day, which is nothing, right? $2 a day worth of ads. But in order to drive traffic to the YouTube page, so if you'd be so kind as to go to facebook.com/uncivil law and like the page, really, it's right there, facebook.com/uncivil law. Are you doing 2 L's? It's uncivil law. There's 2 L's. Is that not working? No? Yes? No? Here, I'll post it in chat. See if that works. God, it didn't come up on search. Yeah, it's brand new. I wouldn't expect it to. It's brand new. There's no likes yet. So if you go on there and like the page, I'd appreciate it. In fact, I'm going to make a post in announcements on Discord as well. So if people would like the page, I'd appreciate it. All right, guys, I'm out for now. If you have any comments, you can obviously leave them on my Facebook, or otherwise, you know where to find me. Love you all. Peace out for now. Bye.